The more facts you give, the greater friction you create. That's why I say don't let the facts get in the way of a good story.
Welcome to Between the Briefs, a podcast by Steno. We share practical tips and expert insights on the pre-trial process, court reporting, and legal technology to keep you updated on how technology is revolutionizing the litigation process and the wider legal sector. I'm your host, Adrian Cea.
Hello and welcome to Between the Briefs, brought to you by Steno. I'm your host, Adrian Cea, and today we are joined by Andrew Finkelstein, the managing partner of Finkelstein and Partners LLP, a distinguished trial lawyer and consumer advocate with decades of experience in personal injury law. Andrew has a reputation for his tireless efforts in seeking justice for his clients, including numerous multi-million-dollar settlements. He has also played a key role in high-profile cases such as the 9/11 Victim Compensation Fund, and his leadership in nationwide litigation has made a significant impact in the field of consumer protection. Andrew has a long history of using his legal expertise to fight for individuals against powerful corporate wrongdoers, and his advocacy has earned him numerous accolades, including recognition as one of the top attorneys in the country. Today, we'll be discussing personal injury and law, the intersection of AI and technology and personal injury law, and the evolving nature of client representation in the digital age. Andrew, welcome to the show. How are you doing today?
Yeah, I'm doing great. My pleasure. Appreciate that kind welcome. I'm going to have to get a link to this podcast and have my kids listen to it now.
I'd love to hear it. So let's just start at the beginning. What got you involved with personal injury and really consumer advocacy?
Well, the firm was started by my dad. I graduated law school, Brooklyn Law School, and joined him right after law school. And the day after I was admitted, I started picking my first jury and went from trial to trial to trial. And his practice was 100% plaintiff's personal injury. And it's just really how I grew up professionally.
Would you say having family that has been, in law is kind of just cut your learning curve and allowed you to get into the field a lot more easily?
Yeah. The short answer is absolutely. I always joke that in my crib, I had the mobile going around that had numbers on it, and they were all 33 and a third. And then I couldn't understand why I was the only kid who had a fraction as a number on my basketball uniform, 33 and a third, which is what my father's contingency fee was. So it was embedded in me from the beginning.
Adrian, I kind of want to pick up on something that you started there. And Andrew, you were picking a jury right after you sort of began your practice. That feels sort of like a lost art. And I wonder if you have any thoughts about the evolution of how people are learning this practice straight out of law school and the positives and the negatives there.
For background purposes, I'm not exaggerating when I say the day after I was admitted, I was picking my first jury. And the real question is why? Because the stakes weren't big. At the time, judges allowed lawyers, at least in the areas where I practiced geographically, you could go pick a jury and you could go try a case, and it could be at the time in the state of New York, the minimum insurance coverage was $10,000. So I could go try a 10,000. Didn't matter what the injury was. The most I could collect on the insurance was 10,000. So there's little to no downside. And judges tolerated that. And I think I've seen that certainly during my years of practice, a complete evolution that judges have taken on the attitude that even if small cases, they just, technically they're entitled to their day in court, but they're not willing to give people their day in court. So it's those are the cases that get adjourned all the time. And when I started, there were weeks where I picked 3 juries in a week, right? Pick my first jury, Monday, case settles, Tuesday, next case, pick a jury, and then sometimes on Wednesdays, right? That wasn't frequent, but judges sent you out. Sometimes the cases got tried, sometimes they didn't. It's very hard now to get judges to let younger lawyers go try their case. Judges, I'm speaking obviously very generally, but judges tend to not want cases to be tried.
You touched on a really big point there. What do you think has led to this change in mentality when it comes to letting young lawyers try their cases?
I think it's really volume as opposed to anything else. Places where I practice, the judiciary is underfunded, so they're overworked. The technology, I think, is overwhelming for a lot of judges. When I used to go try cases, judges didn't care because they really had nothing in front of them other than there was no digital filings. There was no, I wasn't filing motions in limine on cases of a $10,000 policy, it was no work for the judge to say, go ahead, go pick your jury, or I'll go try the case. So when I say it's somewhat of an extreme statement, no work, but the work was much less for a judge to let us go try cases than now with all the electronic filings, and they all have their own different court rules and require verdict sheets ahead of time. It's just more onerous.
If we stay in the space for a second, Andrew, lawyers like yourself who have been practicing for as long as you have, you've obviously seen, and you've just been talking about a big evolution in the practice itself. I'm kind of just curious. Is it hard for you not to get jaded? Is it hard for you to sort of maintain this sense of like real solid advocacy or pursuit of justice? I mean, what keeps that going in you when you see the practice changing as much as you have?
It's the first time anybody's asked me if I've ever gotten jaded, and I can say wholeheartedly not in the least. Because I deal with human beings and I deal with the clients who are really counting on me, and I don't know how I could ever get jaded with what I think is a very noble cause. Now, do I get jaded with the process? I really don't. It's primarily because it's what my DNA is, which is I only get frustrated with things I can control. If I can't control it, then why spend the time getting jaded and frustrated? Because the only person that's going to affect is me, and I can't let that affect me. And I've got so many other more important things to worry about. So that's just my brutally honest answer. I don't get jaded by it, because the day will come where ultimately, no matter how many obstacles the court puts in front of me or a defense puts in front of me, at the end of the day, I will be able to stand up in front of a jury and let the client have their day in court.
What do you do to properly prepare for these cases to make sure that you really give your client the best day in court possible?
Smiling because my preparation is, I don't think, too traditional. I don't really focus too much on the depositions. I don't focus too much on. I definitely read all the records. I'm fully familiar and so on. But at the end of the day, it took me a long time to get to this place. But it's about the story that you tell, and it's about the story of the trial. Who's going to tell that story and how that story is going to evolve. And that's where the preparation lies, not so much in, if I'm reading and spending time reading documents, I'm not thinking about the story I'm going to tell and how it's going to be told. I lecture a lot, and all the lawyers that I work with hear me say this over and over again: never let the facts get in the way of a good story. Right? Everybody's heard it, but if you keep reminding yourself of that, that's not to say that you make up facts. You never make up facts, but you could take the exact same one fact and tell a completely different story around it. So what's the story that's going to go around the facts that you have?
Andrew, how do you teach that, especially to a younger generation? I'm curious, because storytelling in some sense is a teachable art. I find it, when I'm teaching my students, I feel that. But in another sense, there is some like innate ability that people possess for whatever reason to really be good on their feet in front of a jury and telling a story. So what are ways that you go about doing that?
Look, the stories we're telling is the story of persuasion, not really a true story. And what is a story of persuasion? When I say story, of the art of what we're doing, and the art of persuasion, and the best way of telling a story is recognizing what human beings are. And I'm pausing because I do it intentionally, because now you're thinking, well, what the hell is he talking about, right? You're all human beings are prediction machines. We can't help but be prediction machines. So when I just paused, you all were trying to predict what was coming out of my mouth. Now, if I did the exact same cadence, but did so in a way that I knew what was likely you were going to predict, like there's an ultra slippery floor in a high traffic area at a restaurant. What happened?
Start picturing it.
Right? That's the art of storytelling from a trial perspective. So it is breaking it down to its elements as to what is the conclusion that I want people to draw from the facts I will let out in a very strategic way. That's what I mean by storytelling, right? I'm not saying once upon a time and all that. It is, but that's the story of the case. I'll give you. I'll just. Here's an opening of a case that I'm about to do in a month or so, and I drafted this opening, and now I test it with a focus group to make sure they are drawing the conclusions that I want them to draw. Now, I'm not going to read this whole thing to you, but I'll read you the first two. I have a belief that when you start a case, just like what I did in one sentence, you should be able to do in 3 sentences or less. And the jury draws their conclusion. And then everything that flows after that should be confirmation bias. Like, oh yeah, I knew that. Oh yeah, I knew that. Why is he telling me that? I knew that, even though I didn't say it. Because before, I'll give you an example. There's an ultra slippery floor in a high traffic area in a restaurant. And then if the next sentence is, there's a young mom carrying a baby. There, all right. I don't have to say too much. The two of you guys are shaking your head. You're like, I know exactly what happened, right?
Yeah.
So Joe, to you say, how do I teach it? Now, what I do is then I kind of explain what I just outlined for you, and then I have students or lawyers start their story. And it's a very simple process. In the beginning, I have to be able to know right away 3 simple things. What happened? Who could have prevented it, and when? Right? If I can answer those simple things from the 2 or 3 sentences, which you ought to be able to do, then you're well on your way. And then everything that flows after that core, and that becomes the core of your case, you can then draw conclusions from, which is embedding motive. Like, why? Why was there an ultra slippery floor in a high traffic area in front of the maitre d' station? Did they just care about the wrong things?
This is
Right.
great. I love how you piece it together. You're building the story. You're literally just creating the image in your jury's head that then can just flow right perfectly into what your case is. And
Yeah, I'll give you, here you go. On a daily basis, every nursing home must provide sufficient nursing staffing levels to meet all their residents' physical and mental needs. Nursing homes that seek excessive profits by reducing the nursing staff harm their residents, because the residents don't get the full services the home is paid to provide. Now, that's 2 sentences. You guys tell me what happened. You can tell me the whole case.
Oh, absolutely. And well, the thing that I love about that, Andrew, is that your approach there is in those two sentences, you just gave two things that everyone categorically believes to be true.
Right.
Like the fear would be, oh my goodness, my grandmother is in a place where none of what you said is true, and they're doing it not for any other reason than to line their pockets with money.
If you remember one thing, greed is blinded.
Yeah. One thing that I love about what you did there, so storytelling to me is the biggest passion, I think, in my practice too. One of the things that I find really hard to deal with now, and I'm curious if you've come across it too, shorter attention spans. Sometimes if you look at a jury and you realize that this is the longest they've gone without checking their phone. And then secondly, younger practitioners, I really feel like maybe the most powerful thing, and you hit it right from the jump, is learning how to be comfortable with silence. I would play them Ruth Bader Ginsburg's advocacy in front of the Supreme Court back in the 70s when she was doing a lot of consumer advocacy. And when she was getting ready to present, she always began with like 5 seconds of resounding silence. And you can just close your eyes and feel all 9 justices just paying attention to this relatively diminutive woman. So the power of silence combined with attention spans, those two things seem really, really hard to teach. And I'm wondering how you sort of dial that in too.
I do exactly that. What the most acute attention time that you have is when the judge says, okay, Mr. Finkelstein, give your opening statement. Is now that is the announcement to the jury. The show begins. Right? Here comes the show. So are you going to exploit that opportunity or waste it? I exploit it. I stand up very slow, walk over, stand in front of the jury, and I just stand there and I literally look right down and I make sure I make eye contact with every single one of them. I don't say thank you. I don't say, I go, every nursing home, whatever I don't even know what it was, on a daily basis. Because what's going on, and I'll just illustrate it again, is all they're doing is trying to predict because they want to get to their conclusion as fast as possible. So you just put enough out there and it's got to be their conclusion, not my conclusion. It can't be, this is a case where this nursing home owner diverted monies and pocketed into, they're going to be like, come on, bullshit, prove that to me. But if you lay out I think of it as friction. Saying things and using words that do not create friction in the cognitive processes, so that as you talk, they are not saying, well, what does that word mean? How come that fits in? That all happens and you create friction with more facts. The more facts you give, the greater friction you create. That's why I say, don't let the facts get in the way of a good story. That's what I really mean by that. Every time you insert a fact, you're creating friction. Now, if I started that by saying let's just say it's a simple car crash case. There's a red car traveling in the left-hand lane driven by people right away are like, well, why is it red? Why is it in the left-hand lane? Why? Like they're taking every fact and trying to put this puzzle together. So those facts prevent you from telling an efficient, effective story and creates friction. So that's what I mean by don't let the facts get in the way of a good story. Because I just told you 2 or 3 stories and I haven't told you a fact yet.
Right.
And the one fact that I did give you after I started my story, you guys both went, oh shit, which is a pregnant, I don't know what I said, a new mom carrying a baby. That's the only fact I gave you.
But it's enough to make an impact. And I'm curious, have you seen a lot of young attorneys who are just getting into story building use any type of technology, like maybe AI, to kind of decide what questions they should maybe be asking to help build this story for themselves?
I haven't experienced that.
Okay.
When you say young lawyers, I mean, I haven't experienced that they're, now I use AI all the time.
How do
Right?
you use it?
I, how don't I use it is a better question, right? It's I'll use it as to get things going and how can I say this? I'll put sentences in. How can I say it more efficiently? I want to get what's the core messaging I want to say, just for idea purposes in storytelling. I won't put a fact pattern in and say, tell the story, because AI will not exploit the human brain the way I'm talking about doing it, allowing, at least I haven't seen it do that yet, allowing the listener draw their own conclusions.
But that's really interesting to me, because you have this lengthy history of practicing before AI was even a thing. And so you're taking your tradition and the things that work for you and the way you found your voice and the way you tell stories. And now you've got this sort of hyper supercharged at the ready assistant who can kind of be a thought partner in whatever you're trying to do. But you're also holding it somewhat at arm's length in some ways, right? You're not asking it to do the whole thing for you. So does that make you afraid for the younger lawyers who are really learning and coming of age and being trained exclusively with this tool in every area of their legal training, from case law research to storytelling to motions practice? And like, do you get a sense that this new generation is going to have a challenge of actually finding a way not to be so reliant on this technology that is so powerful that it can almost supplant the creative side of your brain?
Well, that's a anthropology question that you're asking, right? Like what is the impact of all these technologies over the growth of humanity, who now has it introduced them? I can't answer that, but I will say this: as long as the individual remains inquisitive and understands what they are trying to determine, and let me put some meat on the bones related to that. Inquisitive is, what are the words that get people to draw the conclusion, right? How can I structure this? And then allowing AI to do that for them, I think it's great. If it is solely just do this for me, then, and without understanding the why what you're doing, like I'll get, like, if you remember one thing, greed is blinding. That's AI. Said, come up with a, because I'll say that 3 times in my opening. So I'll say, I need a short phrase that talks about greed. Okay. And I'd like it to rhyme with, if you remember one thing. And it took a little while, but it helped me get there.
I'm curious, what has your experience been with prompt writing? Because it sounds like you've been through the process of refining the AI to kind of get the output that you want. What tips would you give anyone that is trying to use AI in their practice when it comes to prompt writing and making sure you get the right output?
The longer the prompt, the more detailed you put in, the better output you get. I do use it all the time for things like that, right? I just did it. I had to write a letter to a judge. A client of mine was hit by a DWI driver who was up for sentencing. She wrote a victim impact statement. She submitted to the judge and learned that the judge had sentenced the defendant driver before she even read before the victim impact statement was even submitted. And the client was very upset with me, not with me, but with the judge, and asked me, would I write a letter to the judge? I said, absolutely, no problem. So I said, I went to Copilot, draft a letter to it's a municipal local town judge, to a town judge who, I'm just going to repeat everything I said, who failed to consider a victim impact statement of somebody who was hit by a drunk driver, and that the victim feels violated, not just through the crash, but also that their voice was not heard, and that asked me to send this letter so that you never overlook the victim's rights. And I just said as much as I could in a run-on sentence, and I hit enter, and it wrote a perfect letter.
What do you see? Do you see resistance to AI? Like, do you see peers of yours or sort of being a little bit more hesitant to use it? And if so, do you see the adverse impact that it's having on in any way? Do you see an adverse impact on refraining from embracing this new technology?
I definitely see resistance, and the resistance is from inexperience and not understanding the power of what it can do for you. And I think that resistance is also met with fear of being replaced. And I just think it's frankly just lack of experience with the tool and playing around with it. So yeah, and I think that resistance also is grounded in the fact that ChatGPT, some right out of the box, some lawyers made some stupid errors of just thinking that it could do everything and didn't look at sites. So they submitted some briefs that were the ChatGPT was hallucinating. So then it just created a bad impression, and lawyers are fearful. But that is just totally off base, is all I can say, right? You can't allow it to do the work for you and not check and do everything and look for those hallucinations. But so that's the first part of your question. What was the second part of your question? The positive?
Yeah, I was just asking if there are any sort of tangible, you've seen any sort of adverse effects to that resistance.
Oh yeah, I think lawyers are going to fall behind. That's all I can tell you. You don't embrace it, you're going to fall behind. It's like, it's no different. I mean, I think it's even, let me give my metaphor. If you are a lawyer who still uses a flip phone and you don't have access to your email or can do some type of legal research right on your phone on the fly quickly, or do something, and you are stuck using a flip phone. Yeah, sure, you can still communicate with your office, but boy, look at all the other stuff that you cannot do timely and efficiently. So I'll show you. That's what I keep on my computer. Year of productivity. It's all about creating more and more productivity. That's what AI does. It doesn't replace, it just allows you to do more and be far more productive.
Great, and I completely agree. I would love to tie the conversation back to like the emotional element that you mentioned earlier about telling story. And when it comes to staking up for your client, you hear a lot of stories, some devastating, some, just tragedies. How do you manage this emotional aspect of law and kind of separating it from your personal life into your professional life?
Are you saying how does it not so overwhelming for me? Is that what you're asking me?
Yes.
From an emotional perspective? Well, I wrote a book called I Hope We Never Meet. Because I truly believe it, that if I'm talking to you as a client, attorney-client relationship, that something really bad happened, and I just feel horrible. But I can silo that and recognize the good I'm doing for them. And more importantly, nobody comes to me looking for sympathy or pity. Right. And I don't give them sympathy or pity. I have empathy. There's a huge difference between empathy and pity. So I can be empathetic, but I don't need to take on the harms that my client has. I just have to be able to communicate in a strategic way what has really impacted them. And it took me a long time to learn this. The more catastrophic the injury is, the less I have to talk. There's a direct inverse relationship. The more I talk on the more catastrophic the injury is, and the more I talk, I'm running a very significant risk of overreaching. That's the pool I never want to swim in.
Andrew, you obviously were born with some streak of this in your family, as you talked about earlier. But I'm curious
Well, my father was a very good joke teller, that's for sure.
who were your sort of legal heroes, people who were real inspirations or mentors to you in this space? And I'm also interested, given your focus on storytelling, who maybe your more non-traditional heroes would be, people who you think are excellent storytellers who might fall outside the legal space.
Those are the worst questions for me because I really have a huge difficulty ticking off. I read a lot, but I can't tell you the last book I read. I could tell you lawyers that I definitely look up to, right? Ben Rabinowitz, Mark Mandel, Rick Friedman. Here's the significant difference when I started practicing versus today. When I started practicing, there were no books on how to practice. So, and it was in a relatively small community. I'm embarrassed to say the internet didn't exist. I didn't have an opportunity to, right? So it was local lawyers, just watching them on trial and lawyers within my office and just testing a lot, right? Since then, all these books have been written and I try to read all of them. And there are a lot of great books. But you have to hear the voice of the author and then put it into your own voice. From a storytelling perspective, outside of the world of law, I don't have anybody for you.
Fair.
I don't go to movies. I'm not a big movie buff. I'm not a big, I read books, but I like theater. So the stories I see in theater, for sure.
Well, I love that you just painted the picture that things have changed dramatically, right? Like we went from we didn't even have the internet to now we do. Now we have AI. And that makes me curious, what do you think is going to be next for technology and law? Where do you see it going?
Well, it's inference, right? So lawyers are going to be able to, and you can do it already, but it's not quite perfected yet. But you can take all documents in your file, and AI is going to be able to look at it and tell you instantly where your deficiencies are in prosecuting the case, where your vulnerabilities are. It'll instantly be able to draft your pleadings. And it'll get you 95% of the way there. That exists already. But you need to obviously cross-check it and make sure it's all accurate. It'll be able to do a lot of your, I look at it as a digital employee, right? It is, you just tell your digital employee, tell me what I'm missing in this file, and it'll tell you that. It'll say, your digital employee will say, give me a list of deposition questions for this witness, which is a lot. Steno is a perfect example of that, which I'll talk about. But now, all of that is great. But I'll share with you if for lawyers, when I interview lawyers, this is the question I ask. And Joe, I'm going to ask you this. What do you think is the number one skill a trial lawyer needs?
Listening.
There you go. So now when I interview younger lawyers, nobody says that. Maybe because it's the interview process, and it is the ability to listen. Not just at the words that are being said, but the underlying meaning of why are they really saying that? Are they telling me that because they're trying to cover something up? Are they saying that because they're deflecting to somebody else? Like, what's the motive behind the statement that's being said in the question? Like, if I ask, well, why were you unable to bring your vehicle to a stop before hitting another vehicle in the rear? right? Well, I was overworked. What time was it? What, right? Versus I fucked up, right? It's listening as to, and that AI will never replace.
Yeah. Um, that skill, listening, I think it pairs beautifully with the ability to sit in silence. The things, when I see a young lawyer come to me with a list of cross-examination questions, it's on one level, there's preparation there, and maybe there's structure, and there's comfort in knowing that you have a list of things to ask. But on another level, I'm always reminding them to sort of be comfortable with the uncertainty of what goes on and what comes out, and being able to pay attention to that and then go down those roads as well. Do you think, and this is, again, we've kind of been in this area a little bit, but do you think, how teachable is listening?
I think it's very teachable, because it's teachable if that's what your intent is. So oftentimes that as part of my interview process, I will ask a question that clearly is a question about me, but it's interpreted as a question about them. So they start answering the question about themselves, and I'll say, wait a second, didn't we just recently talk and agree that the most important skill is listening? What did I just ask you? And they'll repeat the question. And I said, well, what was your answer? Isn't that about you? And wasn't I asking about me? Like, you got to practice this. And if you don't practice it, you're never going to get better at it. So you have to consciously go into a discussion saying, I am going to listen acutely. And if you don't choose to do that in a particular interaction, you're just going to fall back on your subconscious, just drawing conclusions without your cognitive brain making those evaluations.
Now, Andrew, we always ask this question at the end of our podcast, and that is, what is your hottest take on the industry right now?
You got to just put a little more definition on that. When you say the industry, what, like, are you
Law,
talking
legal. Where do you think it's going? What do you think is the hottest take that you have on legal as a whole right now?
I think the legal industry is going to be completely different in a relatively short period of time in relationship to the historical nature of it, right? If lawyers existed in the 1500s, 1600s, I don't even know, right? But for hundreds and hundreds of years, lawyers generally did the same thing. That can be usurped very easily by the computer, which is giving advice. But the magic word that I left out is trusted advice. So I think the real distinction between now and the relatively short future is going to be the trust component, and that people are still going to need to sit down with somebody, look eye to eye with them, and make sure that they trust the advice that's being given to them. And that, because people are going to be able to do a lot of research on their own, have a lot of information on their own, but they don't have the legal training. And in the reality is, what is it that they are trusting us with? Right? Not our opinion, honestly. It's our ability to predict the future. That's what lawyers do, like good lawyers do. Here's your choices. If you do A, this is what's most likely to happen. B, this is, and C. Now you make that choice. So the A, B, or C paths, I think, are going to be readily definable by artificial intelligence. But the conclusion and best choice of that is where I think lawyers will serve their greatest role.
Powerful take, and it's a very good one.
I never thought of it before. Yeah, you're the first person who's asked me that, but that's just how I feel about it.
Well, I'm glad we could be the first here. Well, this has been a fantastic conversation, Andrew. Thank you so much for joining us here today. Joe, thank you as well. And do you have any other questions or answers for the audience you would like to give? Takes?
Well, look, I know I was asked to do this. I know this is being put up by Steno. I am a avid user of Steno. This is a unsolicited plug, but I will just tell you that in the year of productivity, it's made me much more productive insofar as like the opening that I didn't read it to you, but I had to go through 10 transcripts, and that I went through those 10 transcripts. What would have taken me maybe 10 to 12 hours, I'm not exaggerating, it took me under 45 minutes to pull the information that I needed from all of them to tell my story.
Well, thank you so much for joining us here today, Andrew. Thank you for the plug. Really much appreciated.
Nope.
And I hope you have an incredible day. And to all our listeners, thank you for tuning in. And we'll catch you on the next one.
Up next on Between the Briefs, I see your motto. It's creative, passionate lawyering for creative, passionate people. What do you do to make sure you foster a good culture of creativity within your firm?
We want our people to feel like their job is just a part of their lives, not their entire lives. And so a lot of how we communicate with our candidates is in line with that.
Stay tuned for the full interview coming to you soon. Between the Briefs is brought to you by Steno. To find out more about Steno and how we combine exceptional court reporting and litigation support services to deliver a superior litigation experience, visit steno.com. That's STENO.com. And then make sure to search for Between the Briefs in Apple Podcasts, Spotify, or anywhere else you get your podcasts, and click subscribe so you don't miss any future episodes. On behalf of the team here at Steno, thanks for listening.